Hello, and welcome to your final review. As you can see in these next few slides, we have quite a bit of material that we will be reviewing today, a whole host of topics. We're going to start with an overview of the final to see what you have to look forward to, and then go back to week 1 and do a brief review of weeks 1 through 14. These are the different topics of the weeks, and this is what we are going to go through today. Again, very quickly. In terms of your final examination, it will be a multiple choice format. My expectation is that because it is multiple choice and it is very comprehensive, you will be able to move through it very quickly. Please remember you have one chance at the final and one chance only. The content that will be covered really runs the gamut from the readings to the instructional materials within the lectures, the media activities, the articles, the videos, all which you have reviewed thus far. It's all fair game in the final exam. It will be pulled, the content of the final exam will be pulled from all weeks. Every week, for each week, you'll have several multiple choice questions. And so it's important that you review each and every week in terms of content. And please remember that although this is a multiple choice final examination, there may be questions which ask you for more than one answer, maybe 2 answers, maybe choose the best 3, maybe choose all that apply, or choose what does not apply. So please read the questions very carefully. Some of the questions will be very general, while others will be quite specific, aimed at particular articles or projects that we did and that have been highlighted. So let's go back to week 1 and start there. It was a long time ago, but hopefully you can all remember it. We started by looking at the general legal duties in cybersecurity. We talked about the idea of reasonable conduct and notice of security incidents. Those were the 2 basic general duties that were covered and that really provide the foundation for cyber law. We then looked and then talked about some of the approaches that the states and the federal government have taken. We first looked at the federal government, all 3 branches, from all 3 branches, we took a look at the Federal Trade Commission, the Securities and Exchange Commission, the Cybersecurity Act, all the things that the legislative branch has done in the federal government. We also looked at the executive branch, talked a little bit about some of the executive orders that have come out in the last decade or so, our National Action Plan. And then we also talked very briefly about about the states and how there was this very clear tension between the federal governments and state governments when it comes to privacy and cybersecurity laws. For example, in privacy regulations, there is no overarching federal framework for privacy, nor is there a federal framework for data breach reporting. And because of this, states, not surprisingly, have taken it upon themselves to create their own laws. In fact, data breach notification laws are widespread. There is actually a different data breach notification law for each and every of our 50 states, and all of them are different. They may be very similar, but there are certain differences that you find in each. So there is certainly this tension which exists between the state and federal government in cybersecurity, mainly due to the fact that the federal government has not yet established any national cybersecurity or privacy standards. We also talked a little bit about the basics of cybercrime, the idea of the CIA triad. Please recall the CIA in the CIA triad stands for confidentiality, integrity, and availability. These are 3 key concepts that permeate this entire course, and I strongly suggest you understand them. We also talked a little bit about some of the basic crimes like phishing attacks or denial of service attacks, and also spent a few minutes talking about some of the legal challenges that are related to cybercrime. Things like standing under Article 3 of the Constitution and class actions, and how those can be certified, and how that can be quite challenging. And again, as you know, later in the course, we delved into these three concepts in a much deeper fashion. But while we were still in week one, we also looked at the target breach, which is a very well-known, extensive breach that was covered in some detail. There were some readings on it. We spent time studying the breach and lessons learned from the breach. Even though it was several years ago, these are still relevant today. And that was really week one of this course, which set the table, if you will, for the remainder of the material that we covered. In week two, we looked more deeply at the laws related to cybercrime itself. We spent lots of time in week two, as you might recall. We spent a lot of time reviewing the Federal Trade Commission, or the FTC, its rulings, actions. We looked at the FTC Act, particularly in Article 5, and the idea of unfair and deceptive trade practices being the foundation from which the FTC could bring enforcement actions. We looked at the role of the Securities and Exchange Commission, the SEC, in that. We also looked at some of the industries itself and how the industry was self-regulated. Main example of this is the PCI DSS standard that were set forth for handling credit card transactions. In terms of enforcement actions, particularly from the FTC, the readings really detailed how these enforcement actions have evolved, and there are a number of rulings. I would suggest that you generally have a good idea of each of these rulings and how they have all shaped the evolution of enforcement actions. These enforcement actions actually set standards for businesses to follow in the cybersecurity world, and as you know, certainly were a wide variety of decisions going in different directions. I also spent some time looking at the cybersecurity laws across state jurisdictions. As we mentioned, there's this tension between the federal and state governments. We looked specifically here at some of the local state laws. In New York, we looked at the Department of Financial Services, or the DFS, cybersecurity regulations. In California, we spent a little bit of time on the California Consumer Privacy Act, the CCPA, or in its amended versions, also known as the CPRA, the California Privacy Rights Act, as well as discussing briefly the California breach notification laws. In week three, we looked at cybersecurity litigation, and we spent some time going through the various types of cybersecurity litigation, the various forms that it might take, anything from consumer class actions to shareholder derivative lawsuits, financial institution litigation for breach of financial information, and insurance coverage claims, and litigation, which is becoming more widespread as more cybersecurity liability insurance has been issued. As you might recall, we talked a little bit more about this in week 9 relative to ransomware. We also did a deep dive on this idea of Article 3 and standing under Article 3. We looked at the definition of injury in fact. We also looked at several federal rules related to class action certification, Rule 23A and Rule 23B, what the requirements were under each of these rules and how these can be satisfied, as well as looking at some of the court cases and how they have established not only Article 3 standing, but also class action certification, as well as some of terms of the differences between the different circuits that are making each of these decisions. In terms of claims and defenses in cybersecurity litigation, we talked about the various causes of actions that may exist, whether they be negligence, negligent misrepresentation, breach of contract, unjust enrichment, invasion of privacy, and or breach of implied warranty, and others that were mentioned briefly. And we looked a little bit at some of the defenses that came up as well. The state consumer protection laws were also discussed, and as well as how those influence and impact cybersecurity litigation, how they can add affirmative claims to litigation. And you are also asked and tasked with developing various claims and defenses yourself in a mock litigation situation to give you a taste of exactly how challenging it is to define cybersecurity litigation claims and defenses. Turning to week 4, we looked at specific industries, financial institutions, and healthcare. For financial institutions, we looked specifically at the Gramm-Leach-Bliley Act. otherwise known as the GLBA. For the GLBA, we looked at the safeguards that are required under the GBLA, the safeguards rule, and we also talked a lot about the red flags rule, how it is defined, what elements are required to identify potential problems, and the analysis that goes along with the red flags rule. We looked at the SEC regulations specifically as they pertain to publicly traded financial institutions and how those would impact those same companies. We spent a little bit of time talking about the Consumer Financial Protection Bureau and the role that it plays with respect to financial institutions, as well as various other laws which were covered extensively in the media activity. And I encourage you very strongly to take another close look at that media activity from week 4. In terms of healthcare, as you know, healthcare has its own very unique rules and regulations, which deal with the industry-specific issues that come from the healthcare industry. Obviously, the key is HIPAA, HIPAA, which is the cornerstone for most of the law established with respect to healthcare and healthcare providers. We looked at the healthcare laws, the HIPAA privacy rule, and how it protects individuals' private health information, otherwise known as PHI. We also looked at the HIPAA security rule, which is a national set of standards, as you know, for electronic PHI or ePHI. We also took a look at the HITECH Act and the HIPAA Omnibus Rule, setting forth a national standard for electronic health records, as well as clarifying and strengthening HIPAA enforcement penalties. After looking at these laws, we spent some time looking at the specific cyber crimes that are often seen in both of these specific industries. In the financial sector, as you know, you often see business and disruption claims from DDoS attacks, fraud, and data breaches. In the healthcare sector, cyber crimes tend to focus more on a variety of risks, such as ransomware, data breaches, denial of service attacks, insider threats, and business email and compromise. As you may recall, healthcare is the most targeted industry in the cybersecurity world. And we talked a little bit about legal issues regarding the industry regulations, how these issues, which are unique to each industry, impact the development of cybersecurity. Week 5 was an interesting week in which we turned and looked at corporate risk management. We took a look at corporate risk factors that corporations, businesses, and companies of all sizes really must weigh in determining how they're going to set up their cybersecurity framework. We talked a little bit about how companies identify specific risk factors and who needs to be involved with these determinations within a particular company. As you know, we're talking about more of an enterprise-wide approach as opposed to a siloed approach. And so we spent a lot of time going through these frameworks. We looked at the CIS 18 controls. As you may recall, Vice President Kamala Harris, in her former role as the Attorney General of the state of California, identified the CIS 18 controls, quote unquote, as reasonable security, which may have an impact on CCPA enforcement that's currently ongoing. We talked about the structure of the CIS controls and the controls themselves. We then turned and looked at the NIST standards, otherwise often referred to as the NIST framework. Again, talking about an enterprise-wide management program. We talked about how this framework operates and how companies can effectively use it for their enterprise-wide risk management. Finally, we looked at the ISO IEC 27001 standards. These are specific security techniques for information security. We looked and talked about the roles and steps that need to be taken to develop a security management system and how the ISO 27001 rules can assist with that. And then we spent some time going over the controls themselves and the objectives of the controls. So these are the 3 main cybersecurity frameworks that we reviewed. And then we talked about how one would make a recommendation as to which framework should be followed. In fact, you all had hands-on experience recommending a particular framework for your particular made-up corporation. But questions like, My apologies for the break in recording. But as we were talking about, you did have hands-on experience recommending a particular framework for your make-believe corporation that each of you was involved in a group setting. And you answered questions like, how do you choose a framework? What factors go into that decision? And I realized this was a challenging group project and presentation to develop this skill set, but you all did quite well. So that was week 5 of corporate risk management. We then turn to week 6, and we look specifically in week 6 at anti-hacking laws. We focused on what I referred to as the big 3 anti-hacking laws: the Computer Fraud and Abuse Act, or the CFAA, the Digital Millennium Copyright Act, specifically Section 1201 of the DMCA, and the Economic Espionage Act. Under the CFAA, we talked about the 7 prohibited acts, how these play out in the real world, and the penalties associated with violations of each of these prohibited acts. We then looked at Section 1201 of the DMCA. The 3 key provisions, you may recall, related to circumventing technology or trafficking therein. We talked a little bit about the controversy surrounding Section 1201 of the DMCA. And for example, we talked about fixing your car and whether or not that should be a violation of an anti-hacking law like the DMCA. And then we reviewed the many exceptions to Section 1201 of the DMCA. Again, I would refer you back to your materials. In terms of the Economic Espionage Act, the EEA, we talked about why it exists, how it began, the fact that there are specific prohibitions on economic espionage and theft of trade secrets. We talked a little bit about the violations, the penalties for violations of the EEA, and then we looked at the impact of the Defend the Trade Secrets Act of 2016. As you'll recall, that provided a new civil remedy for trade secret misappropriation that could be brought by private companies on their own, as opposed to having to rely on the federal government. And again, we looked at remedies and defenses related to the EEA. And of course, as we went through all of those, we looked at the differentiation between them and the various impacts that it had on cybersecurity. In week 7, we spent quite a bit of time looking at various cyber crimes. And here's a list of the 6 main cyber crimes that we reviewed. Obviously, hacking. We looked at types of hackers, types of hacking, the motivation for each specific different group of hackers. We also looked at malware, the various forms of malware, how malware, what it was and how it was used for DDoS attacks or denial of service attacks. Again, the motivation and impact of these attacks. We then looked at identity theft. And as you'll recall, there are many forms of identity theft that we covered, and the techniques that could be used to prevent them and also use them as vehicles of attack. We talked a little bit about digital privacy, not digital piracy, as it says here. The various types from pirating software and counterfeiting, and there are many others. We looked at several examples of these and then talked a little bit about prevention as well. Finally, internet scams. As you know, there are many examples of these scams, many of which I'm sure we've all dealt with. And we talked again about prevention. As you'll recall, we spent quite a bit of time going through the cyber crimes. Again, I would encourage you to understand them and make sure that you have a good handle on them. In week 8, we actually had a midterm examination, so we won't have a review of week 8. But when we came back and picked up again, we were in week 9, which was all about ransomware. And of course, as you will recall, the main issue with ransomware is this whole concept of disruption. that the availability prong of the CIA triad is compromised when ransomware occurs. You may also recall that we talked about the various levels of ransomware that exist. The first level, simple encryption or locking of a computer or system and demanding ransomware payment, extortion, or money, at which point a decryption key is provided, which will hopefully provide access to what has previously been locked up. The second level of ransomware is more problematic. Here, we have not only an encryption of data, we also have exfiltration, personal data, trade secrets, intellectual property, and again, extortion in the form of a ransomware payment that is demanded for you to get your data back and also have your systems unlocked. The third and perhaps most devious level of ransomware that is currently in existence, again, includes encryption of your system, exfiltration of data, but this time they are extorting not only you for ransomware payments, but they are also going to go out to your consumers, your patients, whoever it is that you have personal data on that the hackers now have, the ransomware thieves. They're now going to contact those people and extort money from them as well to ensure that in return for a promise that their personal data will not be leaked. And again, as you know, even if you pay the ransom demand, there is no guarantee that the tools that are provided will actually decrypt your systems. In terms of litigation, there were several cases that you can see in the COSF reading. We spent a bit of time talking about the insurance coverage matters. You must look. Part of the problem that we have with insurance coverage and the insurance coverage cases is that at this point, there's no standard language for insurance coverage of cybersecurity crimes. And that applies to ransomware as well. So it is imperative that the actual language of the insurance policy be carefully scrutinized to determine whether or not coverage exists. We also looked at these war coverage exclusions that are found in many policies. Insurance carriers, depending on the language again of the exclusion, may take the position that a hacker group or ransomware group, which is funded or tied to some sort of state-sponsored activity, is might actually trigger the war exclusion and preclude coverage. Very problematic. We talked a little bit about the Merck case, the challenges that Merck had after they suffered from the NotPetya ransomware attack, and the position that their carrier took. And we discussed the challenges in getting through that process. We briefly talked about OFAC and the potential that even paying ransomware may be illegal if the group to which you are making the payment is on the naughty list, if you will, under OFAC. So you need to be careful before a ransomware payment is made to ensure that the group you are paying does not fall on the OFAC list, which will violate that law and lead to further consequences. Again, not an easy problem to deal with. And finally, we talked a little bit about some of the prevention and response techniques that can be utilized to deal specifically with ransomware. Ransomware, which is a massive issue, continues to be very problematic and certainly will continue to be problematic in the future. For week 10, we looked at public-private partnerships, and we looked at some of the key concepts as to why public-private partnerships are so important in cybersecurity. Your readings focused on the necessity behind these partnerships, why it is important to particular sectors, especially in the context of infrastructure. I would go ahead and review those readings. We talked about the fact that the government is involved and that the Department of Homeland Security and the Department of Defense are two of the leading federal agencies which utilize PPPs. And we talked about how these two governmental bodies established useful cybersecurity PPP models. We also covered the role of NIST in setting some standards for these partnerships. And then we looked at various roles in the private partnership landscape, whether they be civilian organizations, information sharing that is encouraged by the Department of Homeland Security, executive orders, and how those have shaped public-private partnerships, and finally, the U.S. military's involvement via the Department of Defense. In week 11, we looked very carefully at surveillance and some of the limitations of particular surveillance that the federal government or the government has. We started our analysis by looking at the Fourth Amendment to the Constitution of the United States, because surveillance on its face has posed several unique challenges. Under the Fourth Amendment, we talked about who's regulated by the Fourth Amendment. We took a look at the Katz case, a seminal case which set the baseline test to determine the propriety of a government's search and seizure. And then again, many exceptions to the Fourth Amendment that have been shaped over the last several decades. We then turned to the Electronic Communications Privacy Act, or the ECPA. We looked at all three sections of the ECPA, including the Stored Communications Act, the Wiretap Act, and the Pen Register Act. I would strongly encourage you to understand the differences between each of these pieces of the ECPA, what they regulate, and how. Each of these has a specific role in limiting the government's ability to conduct surveillance. You should be aware and understand the differences here. We then talked a little bit more about the Cybersecurity Act of 2015, which is interesting because it keeps popping up in different sections of this course, which clearly means it's important. And then we looked at the Communications Assistant for Law Enforcement Act, or CALEA, as it is known, and the obligations that law enforcement bodies have in a system, in being a system which said by electronic communications companies. It's really that relationship between the government and electronic communication companies, which is at the heart of CALEA. And again, specific issues are related to surrounding encryption for these communications companies. As you recall, there was an ongoing battle between the government and Apple in particular related to encryption and what Apple's security requirements were. It all plays into this concept of surveillance that we covered in week 11. In week 12, we look specifically at federal government contractors. As you might recall, there are different levels of cybersecurity requirements for federal contractors based specifically upon the type of information that that particular contractor might handle, as well as the amount. We looked at several different bodies and some laws, including the Federal Information Security Management Act, or FISMA. We looked at NIST. We talked about NISPOM. We spoke about FIPS and DFARS. All of these were covered in the lecture. And again, I encourage you to understand the differences between these and how they shape the law surrounding federal contractors. All of these set forth different rules and regulations, which are particularly stringent for defense contractors. We spent lots of time in both the reading and lecture reviewing defense contractor obligations. In week 13, we really changed course and started looking at international cybersecurity. Of particular importance is the GDPR, set forth by the European Union. It's an interesting twist now with the UK and Brexit, so it'll be interesting to see how the UK develops its own cybersecurity framework, or if they do, or if they stick with the GDPR. All signs point to the fact that there will be significant differences with the new UK law. We then looked at privacy and cybersecurity laws across a variety of other countries, including Canada, China, Mexico, Japan, and Brazil, to give you a flavor of how different countries and regions are approaching not only cybersecurity, but also privacy. Laws such as the GDPR are very impactful on the development of privacy law around the world, in particular the United States. A prime example of this is the California Consumer Privacy Act, the CCPA, and its amended version known as the CPRA, to see how that law continues to evolve to be more in line with the GDPR. We also looked at the rules and regulations in these other jurisdictions. My recommendation would be that you understand the very basics of these laws from each of these jurisdictions, from their title to their purpose to some of their intricacies, again, at a very basic level. Finally, in week 14, we talked about the future of cybersecurity, a very amorphous topic, one that generates a lot of debate and one that is ever changing, particularly with the onset of artificial intelligence, as you would imagine. We looked carefully at the Brenner reading and some of the mutations of cyber threats, how this is continuing. It will certainly continue in the future. We talked a little bit about the challenges of attribution, how these are becoming more challenging as technology continues to evolve and advance, and how we as a society may overcome this. We talked a little bit about judicial constraints, and finally, we spent quite a bit of time trying to understand what the future holds for cybersecurity and cybercrime. Pay attention, please, to the Paremba article, and note that one of the themes there is how we can anticipate future cyber incidents from what we've already seen in the past. So that is a review of the 15 weeks of this course. I must say that it has been an absolute pleasure instructing you. I appreciate all of you and wish you the best of luck on the final examination and wherever your potential higher education challenges might take you. Again, thank you, and once again, best of luck.